All right, ladies and gentlemen, welcome to a special edition of the MSP Initiative Live. It is Tuesday, believe it or not. We're running out of Tuesdays for the end of the year, but today we bring in a special guest returning back to live, Mr. and legal extraordinaire, Brad Gross. How you
That's
doing,
me.
Brad?
Doing well. Doing well. How are you, sir?
Oh, not too bad, not too bad. Last time we talked, we were like 4 weeks into the pandemic.
I think so. Yeah,
I
I
mean,
think it was just it was the early stages of it, and we didn't think. I don't think either of us thought that at this point in the year we would still be going through what we're going through. But maybe the end is near, right? Maybe the end is near.
well, hopefully the end is near. Is not this guy on the sidewalk that looks like he's alive.
Right.
Um,
I'm not saying that the end is near with my cardboard sign. Yeah, that's not what I'm saying. So, mhm.
all right, so let's zoom backwards. Right, we talked a
Yeah.
lot in the previous two sessions. It was right in the thick of things on things about adding protections into service level agreements and MSAs and
Right.
how to correctly scope things out. And I think a lot of people were right at the tip of, hey, should I discount stuff? Should I give people kind of breaks on the agreement, add time at the end, kind of thing, right? And we were talking about, hey, what does your agreement actually say? How do you protect yourselves while still not, while still being a little bit flexible to a degree.
Sure.
And then there's a lot of people who lost customers in some cases, or made concessions, right, to keep their customers going until they were back to
Mhm.
full strength. There was also some conversation around, am I allowed to have my employees come back to work? What are the proper mechanisms? What do I have to do to make sure that somebody doesn't say that I was being reckless as a business leader to ask people to come back to the office, kind of stuff. So a lot of that stuff has kind of played out a little bit, right?
Yeah, absolutely.
Yeah.
It has.
I
It
mean,
has. And we're getting better at it, right? I mean, there's a lot more. When we last spoke about this, it was a lot of hypotheticals. Like, what if somebody tries to come into work, but they're not feeling well? Can I kick them out? Or what if somebody, had tested positive, and before they come back, can I require them to have another test? Right? I mean, there were all these kinds of questions that were sort of in the ether, but now we have actually seen them come into play. The good news is, if you watch the news, that maybe this time, I should say about 3-4 months from now, maybe all these questions will be moot because of vaccines and whatever. But yeah, it's definitely played out, and we are definitely a lot more experienced generally with it, for sure.
Yeah, 100%. So, like, I know we have many states talking about, kind of locking things back down again. So obviously all of those answers still apply. I mean, I really, I invite everyone who's on here to ask your questions if you still have them in the chat box or in the Q&A box, and we'll grab them for Brad and present them. What I want to do, Brad, for a second is really go the other way for a second and talk about what legal challenges have popped up from, you sit in a seat where you see a lot of these come up to your level. And usually
Yeah.
if you're required, it's probably bad. I hate this. Like, yes, I want to talk to you before I have a problem, but if I'm coming to you when the problem's already existing, there's probably not great news. So you've been sitting in the collector seat, if you would, on a lot of those scenarios. So I'm curious,
Right.
for the people watching this, what challenges have popped up in our space since this thing has all kicked off, right? Like, has it been
Yeah.
not updating your agreements? Has it been, customers, trying to find a loophole to get out? Has it been, legal challenges to the contract saying that, it's no longer valid based on the current situation? What if
Right.
I didn't put a minimum in? Like, there's all sorts of scenarios. So I'd
Yeah.
love to hear from you.
You know what it is? It was COVID did not create new and distinct legal issues as far as MSPs are concerned from a contract perspective. What COVID did was uh, it underlined and aggravated a lot of the conditions that MSPs already had,
Right.
because as companies started to rely more on a distributed network, right, distributed workforce, they started to outsource things to service providers, TSPs, MSPs, and so forth. the weaknesses of those companies and their contracts and their agreements and so forth started to come to light. Right? It started to, now all of a sudden, it was really important, for example, that we focused on security, right? It's very important, for example, that we had statements of work and service descriptions that actually were written in plain English that people could understand, and not with such ambiguity that an employer who is otherwise preoccupied with COVID and employees calling in sick or trying to distribute the workforce, they were just, making assumptions about things that they shouldn't have. And that was sort of the warning that we gave out months ago when we talked, that we said, listen, these things are going to come to the surface, and that's why you need to address them now. And obviously some of the biggest ones that we have seen relate to description, statements of work, how you are describing the services that you're going to provide, and how you are able, if at all, to talk about and reconcile areas that you didn't cover so well in your agreement. Right? What do you do? Do you immediately go to court? Do you fire the client? Does the client fire you? Do you, I don't know. What are you going to do? Those are the areas that we're seeing a lot of issues, being raised.
So like one of the things that has come to light, and maybe it's just because I've had my fair share of traffic citations this
Just tell them
year.
you know me. They'll let you off. It's fine.
Yeah. COVID should work for the reason why, I was going the speed limit. But what we've been hearing, Brad, across the country is that the court systems are largely super backed up, right? So if there is a legal challenge, you may not have the normal, like it's not fast to begin with, right? In many cases. But now we're talking about the line is long and wrapped around the building.
Most definitely. Right now, the worst place to be is in court, not just because of the obvious litigation and the pressures that come with it, but the backlog of cases in court right now is incredible. It's incredible. And so you definitely want to try to resolve things without taking leave of court, without even having to go to arbitration. And the best way to do that is to understand, and this is the key, to understand the realities of the environment in which you're operating, right? To understand where the deficiencies and where the ambiguities occur, because those are the friction points. Those are the points where you and your customer are going to come to blows, and then it's going to, lead to attorney's letters and so forth. Areas that relate that I would say are probably vulnerable to ambiguity relate to obviously security. Not only the type of security that you're providing, but security awareness training is also a vulnerable area, vulnerable to ambiguity. Backup and disaster recovery, right? These days, that's a very big and important issue. It always is, but now it's even more important as workforces become distributed, things get mixed up, and then they turn around and say, we need our stuff. Let's recover our stuff, only to find out things weren't backed up properly and so on. So that's another area. And general support, general support about what is covered under a technical support contract, the service level, what is not, when are things billable, when are they not. All of these kinds of issues need to be addressed in your documents. If they're not, they're going to lead to the ambiguity that the client is going to hold against you, and then we have problems.
All right, so let me throw a couple scenarios out there and see if it lines up with what you've been seeing. Customer drops their service agreement to from 100 employees down to 2, and you didn't put in a base or minimum
monthly fee.
Correct. So now they're saying, hey, you quoted me X number per computers or per employees. I have 2. That's what I'm going to pay you. And now all of a sudden you're underwater, right? Because there were hard costs involved that you're
right.
How do you handle that?
Okay. So that's, what truth is that I don't, in those scenarios, I mean, we're speaking hypothetically, so there's no one single MSP that we're focused on right now, but I would say shame on the MSP for a few reasons. All right. And I'm going to take your hypothetical and run with it a little bit. First, in your documents, there should be a minimum monthly fee. right? If there isn't, then that means that you, as an MSP, as a service provider, did not think through all of the scenarios that could happen. And one of them, obviously, is dropping a project down to the point where financially it doesn't make sense for you to be involved, right? You need to be able to either maintain a minimum monthly fee, or alternatively, you need to be able to fire your client under those situations. And usually neither of those is adequately addressed, at least when they come to see me and I look at their documents and it's just not in there at all. So that's the first scenario. The second scenario where this becomes a very big problem is the situation where you have an agreement that says if you terminate without cause, then you have to pay out the rest of the statement of work, right? The rest of the service for the year. Okay. And let's say a client is 8 months into a 3-year deal and they're giving you $5,000 a month. Okay, not bad. So now the client says, well, if we terminate, we have to pay out the rest. Okay. We're going to drop our service down to $150 a month. Right? Again, you don't have a minimum monthly fee in there. Now they drop it to $150 a month and then they terminate. Well, now they have to pay out the rest. Yeah, well, the rest is $150 times whatever the months are, right? Not $5,000. Major difference, right? The customer might say, yeah, $150 times whatever remains, 22 months, I'll write you a check. No problem. And I'll write you a check for $3,000 and we're out. So that's another, you see, the idea behind the scenario that you just brought up, and it's a good one, is that when you're drafting these kinds of agreements and statements of work, you need to think about worst case scenarios. They laugh at attorneys. They laugh at me for reasons, other reasons besides agreements. But anyway, no, they laugh at attorneys for thinking about worst case scenarios, right? Oh, you're always doing this and it's a doom and gloom kind of a thing. Well, you know, truth is that what you just brought up is a very common scenario in this crisis. Businesses have gone down, so they've reduced their number. The number becomes economically unsustainable for the MSP, and they're without remedies. So these are the kinds of things you need to think about.
So what about this scenario, right? And this actually happened. I know several people had said that this had happened to them.
We're going to change the names to protect the innocent. Is that what we're going to do?
Yeah, I'm not going to put names, but yeah, you can put whatever name you want in there.
Okay.
Smith, Hannibal Smith from the A-Team. You know, business owner tells all the employees, unbeknownst to the MSP or IT provider, you just pick up the computer off your desk and take it home and plug it in. And have been running on this. You know, obviously you found out after the fact, this is what happened, right? And now they're saying, well, if there's a problem with, you know, employee X's home computer, which is actually the work computer that they took home,
right?
On your agreement, you got to go to their place and fix it,
right? Because well, it's like you're hitting all the pressure points today. It's like you're like the kung fu master of problems today. The basis of that, right, is largely rooted in a contract that lists what you're going to provide, but not where and how. Okay. So any good statement of work, any good statement of services needs to think of the who, what, where, when, and how much, right? And you know, the where needs to be answered, especially with distributed workforces, because you're right. If I say that I'm going to provide antivirus and monitoring and maintenance and so forth for these particular computers, well, I haven't said that they can't be moved. I haven't said that you can't modify your infrastructure. So you're 100% right. Suddenly they're dealing with home networks that have different firewalls and different configs. And yeah, you're sort of caught in the rut of what do we do? That ambiguity, right? So every statement of services needs to address not only what you're doing and how you're going to do it, but where you're going to do it. We are going to provide the services to those, you know, to that hardware, that software located at this physical address. That's it, right? This particular location. It is such a simple thing for everyone to go through their documents right now well, after this webinar, and say, do I answer the who, what, where, when, and how much questions? If you don't, make sure they're in the documents. For sure. Yeah.
Here's another one for you. Let's say the customer got behind, right, early on their bill, right? And they're still behind. They're paying, but they're behind. But the problem is, like, now you're getting towards the end of the year, you're running into a wall, right? From a math standpoint. Like, you've been technically bypassing the terms of your agreement because you've let them stay behind for months now, right?
Right.
Like, can you still go back and use the contract to terminate due to non or
Yeah. What you're doing, okay, the answer is, so if this were like a law school exam, the answer would be, well, sure you can, right? I mean, sure, they've breached the contract. You have, that's what a statute of limitations is for, right? It gives you, depending on the state you're in, anywhere from 3 to as many as 6 years to enforce your contract, and you could do what you have to do. All right. That said, what you're setting yourself up for is, well, is failure. And I'll tell you why. Because if I were representing the customer in that case, and they called me and they said, we can't have this guy stop our services, help us. All right. So the first thing I would do is notify the MSP that what they're doing is going to cause the death and destruction of everybody, right? So you set it up in a way that it makes it sound like that now the world will truly come to an end. And then I would raise an argument of waiver. You waived the right to enforce this particular contract because you didn't enforce it in month 1 or month 2 or month 3 or month 4 or month 5. Now, would that be a successful argument? I don't know, but it would be an argument. And then I'd raise another argument of something called latches. Latches is a fancy lawyer's way of saying that one party waited for the perfect opportune time when the other party was in a worse off position and then launched a lawsuit. And the idea is you're supposed to launch when you know of the problem, not sort of wait until the other party is in a materially worse position. So I'm going to argue the world is going to end. You've waived your right. There's latches. By the way, if I really have to go back and look at all the services and so forth and do an audit, I'm sure that you've probably dropped the ball once or twice. And what I'm doing right now, and this is what an MSP would face, I'm setting up the MSP to now incur so many costs, so many fees, that they're now either going to write off the time, write off the money, right? Or continue to allow their customer to not pay the bill. None of those scenarios are particularly good. All of them can ultimately lead to the demise of an MSP, right? So the idea is that you don't want to get into that position. You want to make sure that your documents are enforceable, that you're not waiting too long, and that all of these little situational realities that you're bringing up here are addressed in your documents. Because if they're not, well, you'll be paying $300, $400, $500, $600 an hour to argue. And who can afford that?
Adds up very quickly. A couple questions have popped through as we've been talking. So
Sure.
Ron asks, what is the difference between a statement of service and a statement of work?
Well, nothing. The way I'm using it they're interchangeable. In my world, if you've heard me speak before, either between George and me or at any industry event, you'll know that it is my mantra that every service provider needs to have a master service agreement, a master agreement that it is its constitution, right? And then it needs to have another document that is a narrative that describes the who, what, where, when, and how much. That other document, we can call that a statement of work. We can call it a quote. We can call it a proposal, right? But that document is not attached to the MSA. It's never attached to the MSA. It is not an exhibit to the MSA. It is not a schedule to the MSA. It is not included in the MSA. It is governed by the MSA. It should begin, this document, whatever you want to call it, service statement, statement of work, service Bible, whatever you want to call it, is governed under that master service agreement in existence between us. If you don't agree with that agreement, don't sign this statement of work. Okay. So long-winded way of saying there's no real difference between a statement of service and a statement of work. It's nomenclature, but make sure that you're consistent throughout. If you're going to call it a statement of service, then make sure your MSA says from time to time, we will issue you statements of service, right? Or statements of work. Try not to use different words and different terms, because then you're injecting ambiguity into your agreement.
Okay,
So,
another one. That's a great answer. Another one that comes through from Brent, my favorite questioner here at MSP Initiative. I would assume that hourly project fees should be defined as well. Do you have a suggestion for the rate difference between on-site services versus online? Meaning, let me rephrase that, right? Let's say you've been delivering the majority of your services on premise, right? You show up, you do your work. Now the pandemic hit, you shifted to remote, obviously. Now there's a question of, well, it's not costing you as much, right? You don't have to show up here. You can do multiple things at once. You should give me a pricing break. Is that even a valid conversation?
No, not in my world. It's not a valid conversation. I mean, look, there are a couple of things. I'm not one to tell an MSP what they should or shouldn't be charging. All right. That's not my role. It's not what I do, but I can give you some guidance about the issues that you should be thinking about when thinking about what you're going to charge, right? First of all, just off the top of my head, there is the issue of on-site versus off-site. I think that you need to make it very clear that the prices that are in your statement of work, statement of service, whatever you want to call it, that they contemplate on-site services. You should say that specifically. These contemplate not on-site, off-site services, remote services. And that if you want on-site services, there will be additional fees. Contact your technician, contact us. That's one idea that you should be thinking about, on-site versus off-site. And again, clarify that the prices generally reflect off-site services. All right. 2, I think that you should be thinking about the fact or saying that prices generally reflect automated payment, right? Automated payment. Because if you have to sit and wait for a check every month, and then sometimes it's going to be late, and then you have to have somebody send a letter, right? And so on, there are real administrative costs involved. And in my world, you should be able to charge for those if necessary. And so the second thing, and I could think of one other, but the second thing that you should be thinking about is saying in your documents, the prices in this document contemplate automated payment, ACH, credit card, which they should keep on file, and so forth, right? Any other payment method might require additional administrative fees. That's the second thing. The third thing that you should think about is fee increases. All right. Now, everybody says, oh, yeah, Brad, I always think about the fee increases. We have the right to raise our rates once a year by 3%. Okay. You're wrong. You're all wrong if that's what you're thinking about. I don't know. You could Google it, so don't hold this number, against me. But it was about 10 years ago or so that there were floods in I think it was South Korea. And what happened was the price of memory and hard drives shot up like literally, like 1,000% overnight. Literally. I mean, something that cost you $10 is now costing you $150. I mean, it was something crazy. And what happened was all these companies were sort of caught because they were locked in. They said, well, we can't even raise our prices enough to cover that, right? Because you had the standard, we could raise it by 3% or the cost of living increase, and it's all crap. All right. That's no good. What I want everyone to do, if you're hearing this, right, I want you to consider putting something in your documents that says, we can raise our prices, okay, at any time by giving you notice. Now you'd say, who would ever agree to that? No customer would ever sign that. I'm not done, okay? What you want to do is you want to say, we can raise our prices at any time by giving you 60 days notice. All right. But here's the deal. If we raise our price by more than 5% over the prior year's fees, you will have a 30-day window to terminate the service. If you do not terminate the service, then the fee will, be implemented 60 days after, and we continue with our agreement. Now, why am I suggesting this as a paradigm? One, by saying that you can increase your fees by pretty much any amount, you have avoided the flooding problem, right? The flooding, overnight flooding problem. Okay. Two, by giving a client a way out, right? By saying that if we increase it by more than 5% over the prior year's fees, you can get out. The client doesn't feel like, oh, so you're going to raise it by, 3 or 4 or 5 times the amount and I'm stuck. No, we give you an exit strategy. Okay. And why is all this important? It's important because if you find that you have to raise your prices by more than 5% over the prior year, and by the way, 5% is a placeholder, 10%, use whatever number works for you. But if you have to raise your prices by more than that amount over the prior year, you know what it means? It means that every one of your competitors had to do the same thing. Had to do the same thing. If all of a sudden I found out I have to raise my hourly rate to $2,000 an hour, which by the way would be awesome, but and I digress. If I had to raise it $2,000, why am I doing that? Well, I'm doing that either because I have suddenly become an overnight immediate celebrity, right? Which would be great. Or I'm doing it because something has occurred that everybody is doing that. All my competitors, all fellow law firms, right? They're all charging that for a reason. Maybe insurance went up, maybe, I don't know, whatever it is. Okay. So I'm doing it and I know that my client or my customer is not going to find a better deal elsewhere. So think about it with your service. If you have to raise it by 15%, it's probably because your upstream provider raised its fees. And you could say to your customer, go look around. Go look around. Go to, I invite you to look around. You got 30 days to look around, but they're not going to find a better deal. So everybody is protected.
So this doesn't just apply. This applies to anything, right? Like, let's say tomorrow Microsoft comes out and says, we're doubling Office 365 prices.
Right.
Oh, so this applies to any upstream service that's included as part of your deliverables.
100%, 100%. And, we kid. And, obviously it was an example. Microsoft is not doubling overnight. I mean, maybe, but probably not. But things like this have happened, right? Things like this have happened where all of a sudden fees maybe not double overnight, but over the course of 2, 3, 4, 5, 6 months, they do. And you guys might be in longer term contracts, over a 3-year deal, you might see that price double or triple or quadruple. So yeah, you want to give yourself an exit strategy, all right, to allow yourself to increase these prices if you have to. So you're going to move off of your pricing, but you also want to give your customers the ability to not feel like you're just going to be in total control and they have no say. It's a nice balance and it protects you.
This saves litigation times, what you're saying, right? This is going to keep it out of the courtroom.
Saves litigation or at least attorney's fees, right? The letter. You can't charge this. Well, yes, I can. Well, this goes against the spirit of your agreement, and this is out of the ordinary and outside of industry standard. Well, we never promised industry standard. I mean, right now, I've just rattled off 2 letters back and forth. You've spent $1,000 already, right? You've already spent $1,000. Why should you do that? Just put something in your document that says, we can raise it. We'll give you an exit if it's above a certain amount. And if you don't exit within the period of time, that's it. Done. That took 30 seconds and I've saved you $1,000.
Okay. So this one.
Somebody owes me $1,000, George.
Okay. I'll just add it onto my bill. So this one's a little bit more timely, right? Because it's happened, right? We've had major providers, I can put whatever name I want in there, who have had multiple outages within a short period of time. And of course, you're billing your customer, right? So they're looking at you because they're not paying the vendor directly, right? So now they're looking at you to give them a break when your upstream vendor's not giving you a break, right?
Yeah.
So how do you really handle, like, how does the MSA handle that, right? When you're really passing through another service, let's say an Office 365 again, right? And it's not in your control, but your customer's affected, right? So what do you do?
Right. I mean, there's the legal end, there's the business end. From a legal perspective, you need to make sure and make it clear that you are in many ways simply reselling another service. I'm always surprised to see how many MSPs in their documents don't actually state that they are reselling an upstream provider service, and that if the prices change, and that if the services change, or if there's an outage from the upstream provider, that is something that needs to be passed through and for which the MSP needs to be held harmless or blameless. Okay. So right off the bat, from a legal perspective, your documents need to make it clear. It is about managing expectations. Mismanaged expectations create the most bitter arguments, because each side thinks he or she is correct, right? A mismanaged expectation, a miscommunication, everybody thinks they're right. It's not like one party says, well, I don't know if I'm right about this one, but I'm going to fight to see what I can get. It's not like that. Everybody turns around and says, I didn't do anything wrong, right? So the first thing is make sure that you mention that you're selling an upstream provider service. Next, as far as, businesses go south, I think that MSPs need to, it's now sort of one of those risks of doing business that when you are under an obligation to pay a licensing fee to an upstream provider, hoping that your customer will pay you or maintains it, it's sort of a risk of doing business these days. My advice is to either take a deposit, right? You can do that. You can have very, very short leeways as far as giving the client the ability to pay timely. Like if they're late, they get 5 days. Otherwise, you cut them off and try to move those licenses elsewhere. But in truth, it's a very difficult problem when a client just simply says, I fired half my staff. I don't need 100 licenses anymore. I only need 50. And they're saying, well, I bought 100 on your behalf. What am I supposed to do? The answer is it has to ultimately go down to your client, but I would keep in touch with your client. And I think that the importance of contact and what we call the stickiness, right, between you and your client, it's more important than ever. If you see that your client is having problems or the customer is not paying, maybe is a couple of weeks late, then becomes a couple of months late, reach out, because those situations where the client says, I can't afford it, and you're on the hook, it's a tough situation because you can't get, what do they say, blood out of a stone, right? You can't, the client can't pay you and you're on the hook, then you're on the hook. So I would just suggest keeping in touch with your client to avoid those situations.
A couple of questions come in from Brent again. One, he says, where should I send
Brent?
Where should I mail the check to? I was like, okay, he's working at home, but I'm sure he's gonna say send it to the office. And then here's a more targeted question. So where does the expectation go? The MSA or the SOW? The master services agreement or the scope of work?
So when you say expectation, I'm not 100% sure about which expectation we're talking about, but let me try to answer it anyway. And while I'm doing this, maybe you could clarify in your question. An MSA has to handle legal and it has to handle situational reality. If it doesn't do both, then your MSA stinks. It stinks if it doesn't do both. Legal is the stuff lawyers love: indemnification, limitation of liability, warranty language, right? All that stuff, big capital letters, lawyers love to write that. Okay, that's important. That goes in your MSA. Situational realities, though, are the realities that you're going to face every day when you're dealing with your customers. That's where the rubber meets the road. And there is a miscommunication, a misunderstanding, a mistake. Sometimes things happen, right? And you need to know what you're going to do. If you are sitting back going, all right, now what? I don't know, now what? Well, then your document has failed you. So you have to think of this parade of horribles that could happen. For example, transition. Client hasn't paid you, but still wants its passwords because it's going to another vendor. Do you have to give the passwords? Should you give the passwords? BYOD, they're plugging things in and out of the network thinking, oh, it's all right. If we mess it up, George will fix it. Do you have to do that? Have you set that expectation? Because you and I know, and all the people who are listening are probably nodding their heads, that these are the things that happen all the time, right? Regulatory compliance. Just because you say that something is compliant with HIPAA doesn't make the customer HIPAA compliant. Very big difference, right? Although the client might, your customer might say, yeah, I'm compliant with HIPAA because, you know, my MSP took care of this. No, 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 no. You need to make it very clear, right? These are the realities. Reality of a security solution is never 100%. And that the client should be advised specifically to not only implement a security solution, but train its employees, because you are not going to cover security events that aren't explicitly listed in your statement of work. These are realities. So you set expectations in the MSA, then fill in the details in the SOW. But let me hear the exact one.
So his example, which actually happened, I think just at the tail end of 2019, he's like, the license count issue, right? You brought many, the client drops the license. Well, if you remember, Brad, this was a story that popped up in all the industry publications, right? MSP was servicing the local, was it like Chamber of Commerce or something, right? They didn't pay their bill. So he says he shuts off his Office 365 to not incur additional costs.
He got arrested, right?
Something got arrested.
Yeah.
How does that happen?
It happens because, first of all, I believe they shut it off to the Chamber of Commerce that must have had connections. You know, as a former prosecutor in 2 different states, I can tell you that that arrest shocked me. It shocked me. I even reached out to see if I could file what we'll call an amicus on behalf of the MSP. Because that was just ridiculous, that arrest. But I'll tell you, those types of issues need to be addressed by contract. For example, if you have a contract that says, right, if you don't pay our bill, you agree, we can suspend. All right. And if you are suspended, right, then we don't have to provide any further services to you. Now, by definition, in your contract, it says services include the retrieval of passwords, the retrieval of data, the provision of whatever, fill out a whole list, okay? And the client doesn't pay its bill. So and then it says, I want my password, I want my data. No. Is it a criminal thing? Of course not. You've taken it out of the criminal context. You've taken it totally out of even the possibility of it, and you've made it a contract matter. And then you hold up the contract. I wish I had a piece of paper. I just hold up a blank piece of paper and say, Judge, by contract, they agreed that the retrieval of passwords is a service. And in the sentence right before that, it says, we don't have to provide this service if we have not been paid. At that point, you're out of the weeds, right? You're into the world of contracts and formalities and so forth. So I think that these kinds of things need to be expressly stated. And I think that you don't, and you should not be scared of saying them. It's like building a high fence. High fences make good neighbors, right? As far as your specific one about monthly fees and so forth, I believe that that should probably be in a statement of work. You know, the master agreement says something to the effect of, if you don't pay us, we could suspend service. And the master agreement could even say, by service, we mean not only that stuff that's in an SOW, but also the retrieval of passwords, admin config settings, or whatever might be applicable to your situation, global. But in your statement of work, repeat it. Make it very clear what will and will not be done, because that's the document that the customer is going to refer to when things go wrong. Right? When there's a question, they don't usually whip out the agreement, they whip out that statement of work. And they say, what am I entitled to here? What am I supposed to be getting? So put it in there as well and make it very clear, and you should be okay.
So, well, Ron actually just popped up with the question. I was about to shift thoughts. He says, any suggestions of someone that could help us make an MSA and an SOW?
Let me think. If only there was an attorney that has counseled over 1,400 MSPs over 20 years. And I don't know, George, have you ever met someone like that? I
don't know. I'm struggling to think of finding one. I don't know.
That's a tough one. If only there was someone who understood this industry.
Ron, no. hang on till the end, and you'll get
George will give you the
contact information. Okay, so here's one for you, Brad, that I think you probably heard as well. Pittsburgh Airport, right here in Pennsylvania, on the Philadelphia side. It's on the other side.
Isn't that the airport that has a big T-Rex in the middle of it?
I don't know. I've never flown out of
Whoever
Pittsburgh.
asked the
I
question,
digress.
let me know. I think that is. They have a big T-Rex in it. Anyway, go on.
So,
Yes.
so they sued their MSP after a federal agency came in and said that your network is being infiltrated because your MSP did not properly patch your system.
Right.
And so the federal agency came in, did all this work, fixed the gap. Airport sues MSP. MSP is like, well, hold on a second. What do you mean? What is your definition? Why are you telling me I didn't patch? I patch. What are you talking about? Is this something outside of just Microsoft products? So it's in court now. We know that the court system's backed up. We're probably not going to find a final on this until 2021. But I don't know if you heard about that case, but it's one that kind of raised a lot of eyebrows, right?
So yeah, I'll tell you, there are a couple of things about patching. There are a couple of issues two that come to mind that are crucial. The scope of it, and the issue of when is it required. Now, by scope, I mean that just because you are managing an environment doesn't mean that you are then responsible or should be responsible for patching everything in the environment, both firmware and software side, okay? Your document, okay, your quote, your statement of work, your service statement, whatever we were calling it earlier, that should specifically say that we're only going to patch that hardware and that software that's listed here. And then you're going to list it, right? Or if there are a line of business applications that are specific, you're going to list them. Or if they're excluded, say the following are excluded, line of business applications, right? The idea is you want to put your arms around the scope of what is going to be patched. So somebody can't turn around one day and say, well, you're managing our environment, right? You're managing our environment. And, it seems to me that it says you're going to patch. Yeah, we are going to patch. And well, we have 6 line of business applications. So you'll patch those too. And then there are crickets, right? Who's right? I don't know. Right? You could see both arguments. Well, you said you're managing our environment and you will apply patches to the environment, and this is in the environment. Here you go. On the flip side, well, it's a line of business application. It's not normally included in the environment. By that, we meant the standard Microsoft Office and so forth. And, $25,000 later, you figure it out. So 1, put your arms around the scope of patching. Now 2, a very important one. Every document in which you are talking about patching should address the fact that it is in the MSP's discretion as to when a patch will be applied. Okay. As we know, some patches really screw up your system, right? Some are released and they say, this is a must do and this is a critical thing. And then you put it in and it screws up everything. An MSP should have the ability and the right to put it on some sort of staging server somewhere, some sort of, honeypot, and test it, make sure it works, make sure it runs, make sure from a community perspective, it's not going to mess things up. Okay. And then implement the patch. So not only do you want to talk about scope, you want to talk about timing. If you don't talk about either or both of those, then the customer is going to make the rules. The customer is going to say, Microsoft issued a patch. Everyone got it a week ago. You should have had it a week ago. You should have implemented it. You're wrong. You've done a material breach of our contract. We're canceling.
Right. Like a Microsoft patch is always never broken anything.
Never. No, they're perfect all the time. So, the idea is that set the ground rules, because if you don't set the ground rules, your customer is going to set the ground rules. And I can assure you, when your customer sets the ground rules, it's not in your favor. It's not in your favor. So make sure you do it in advance.
So flipping to another one that seems to be quasi topical, right? Is the fear of, regulation finally hitting our world, right? From a, you have to be certified to be a plumber. You have to, be licensed to be a lawyer right? There's no formal license to apply to be an IT guy or a service. Right. And we've heard of, like Louisiana rolled out there, hey, you need to identify yourself now, right? Like if you're calling yourself left or right, time to raise your hand because we're going to start collecting lists and such. What happens when an MSP or IT service provider or solution provider, whatever you call yourself, maybe over markets themselves? Like the one that's common, right? Oh,
Yeah.
I'm calling myself an MSSP
Right.
versus an MSP, right? Like all of a sudden you subscribe to a tool and now you're out there saying I'm the man, right?
Yeah.
What
Yeah.
like that? This can get you into trouble, clearly.
Yeah. What happens in those cases is we send a retainer letter out and we start the process, because when MSPs engage in what I call puffery, right? It's puffery. It is saying that we can do things that you can't, or saying that we are industry leaders in whatever, and you're not, or recognized in the industry providing a full range of whatever, and you don't. All of these things, okay, will come back to haunt you. They will appear again, but usually in the context of being an exhibit to a court complaint, right? So what you want to do is you want to take all puffery out. If, first bit of advice, if you can do something, then by all means, tell us what you can do, right? Don't be bashful. Tell us what you can do. But never put that stuff in your MSA. Never put that stuff in your statement of services or quotes or whatever. I know that you all believe that you are recognized leaders in the application delivery and infrastructure management industry. And God, you know, it sounds wonderful to start off a quote that way until things go wrong. And the first thing that your customer is going to do is they're going to pull out that first opening paragraph, which says, thank you for recognizing us as experts in whatever. And they're going to point to that and say, you know, you promised me you were an expert. Clearly you're not. You promised me that you would increase efficiency and reduce downtime. That didn't happen. So take the puffery out of your MSA, take it out of your quote. If it's in there, it should be in a brochure. It should be in an advertisement. And your documents should specifically say that whatever's in our advertisements, if that stuff isn't in this document, this contract, this statement of work, it doesn't apply. Okay. You want to make a very clear delineation between advertisement and your documents. The merging of the two will cause you to incur incredible attorney's fees. And they're also going to give your clients backdoor ways of getting out of your contracts. So you don't want to do that.
No, I'm sure that's not the last time we're going to hear about that happening.
No, it happens quite a bit.
At what point, Brad, do you tell a customer, this is hypothetical, that it's not worth trying to enforce the agreement because it'll cost more to get your money out of it than what's owed?
So great question. And the answer is this. I could tell you that even if you have the ability to litigate or arbitrate, you probably don't want to. I know of virtually no one, and I've been representing a lot of people over decades. I know of no one that has walked out of litigation or arbitration feeling all warm and fuzzy. Okay, that doesn't happen. So my first bit of advice is whatever it takes to avoid litigation and arbitration, do it, because the fees and the costs are one thing. And I'm going to talk about that in a moment, but the mental distraction and I was going to use the word cumbersomeness, if that's a word. It's cumbersome. It's heavy. It's always on your mind. It never leaves. You think it will. You can't segment it in your head. It will always be there bouncing around in your head. Lawsuit, arbitration, lawyers' fees, and so on. So my first bit of advice is always try to get out of things amicably if you can. All right. Next, if you feel like, well, it's a necessary evil, then make sure that your document specifically says that you get your attorney's fees. And the way it should read is that the prevailing party in an action gets its attorney's fees. Now, why is that crucial? It's crucial for two reasons. One, most states in America, I don't know how many, I would venture to say pretty close to all of them, follow the quote American rule, which is that if you have to sue someone under a breach of contract, you don't get your attorney's fees. So you say, wait, I won. That's right. And the other guy didn't even show up. A default, yes. So I don't get my attorney's fees paid. No, that's the American rule. You don't get your attorney's fees unless the contract specifically says if an action is brought to enforce, right, the prevailing party gets its attorney's fees. Changes everything. Now you call me up, George, and you say, this guy owes me $2,000. Should I keep pursuing it without attorney's fees? Absolutely not. Absolutely not. It's not worth your time, not worth my time. It's no one. All right. With an attorney's fees provision, we send a letter. Dear Mary, you haven't paid George his $2,000. Here's the situation. You're in breach of contract. You owe him $2,000. There's a provision there that says if we have to sue you, we're going to charge attorney's fees. My fees are going to be $450 an hour starting 7 days from now. If George doesn't get his money, fees are going to start to rack up. We're going to sue you. We're going to recover it. I assure you, my fees will outstrip the $2,000 you owe George, right? Govern yourself accordingly. Odds are George is going to get a call saying, all right, can we split it? Can I give you $1,500, right? Can we get that done? George is going to say, yeah, all right, fine. That's the key, an attorney's fees provision.
No, that's super important. And just to handcuff that to a degree, why do all these people think that arbitration somehow gives them a leg up from staying out of court? I just see arbitration never going the way that you think that it's going to go.
Well, arbitration doesn't, it doesn't give you a leg up. There's good news and bad news about arbitration. Arbitration, I guess the bad news is that it's not cheap, right? Arbitration is not some way of avoiding spending oodles of money to resolve a dispute, and you walk away saying this was wonderful. No, arbitration in itself, you still have to file an arbitration complaint. It's still done by counsel, right? There are fees. It's not cheap. Now, that said, what's the good news? Well, the good news about arbitration is, A, you can pick your arbitrator. So you don't end up in front of a judge that may have just learned to turn on his ring light on his webcam yesterday for the Zoom conferences he's doing, right? So you could pick your judge, you could pick the arbitrator who's qualified. B, you are not paying for attorneys to travel to court, waiting time, and so forth. All of that is eliminated because a lot of it is done online. Okay, even if it weren't COVID right now, a lot of it is done online. Third and final benefit of arbitration is that, well, two other things. Third thing is that you can require that an arbitration be handled within a certain time period. Parties agree that this will be handled within 90 days or less. Okay. And the fourth thing, of course, is you can also, the arbitrator has the ability to modify rules of evidence and so forth, such that if he or she wants to relax the rules of evidence, they can do so in their discretion. So it's not necessarily as formal as litigation. It's important, it's professional, it has formality to it, but it's not as formal as litigation. So there's good and bad. But yeah, people who think that they're putting in an arbitration clause because that will make resolving disputes almost free, well, they're kidding themselves.
I hope people pay attention to that. I see that way too often. Okay, so for the people that were asking, how can I have somebody either look at my stuff, help me with my stuff, give me something other than a boilerplate template that I downloaded from LegalZoom or something? Well, good news for you. This is exactly what Brad does. This is a day in and day out. I can't recommend a better person who understands our industry more from a, not just from a technical standpoint, which is super important because a lot of legal people have a hard enough time turning their own computers on, but obviously giving it to you straight. And I think that's super important because sometimes the legalese, makes you want to, poke your eyeballs out. So Brad, how do people find you, get a hold of you, request your attention? Sure.
So what they can do is send an email to info, I-N-F-O, at my name, bradleygross.com. That's probably the best way. Info at bradleygross.com, or you can call the office 954-217-6225. Go to my website, bradleygross.com. Ironically, my website was down today. Go figure. I needed a good MSP. Apparently there was a resource issue, which hopefully has been resolved, but normally it would be up, bradleygross.com. But the best way is send an email, info@bradleygross.com. Would love to hear from you.
Fantastic. So everyone who is interested in contacting Brad, just sometimes he takes a minute. He will talk to you. If it's urgent, make sure you say that it's urgent if you got a problem. Otherwise, this whole session and Brad's first and second session are online at mspinitiative.com. You can rewind, fast forward, download, send it to somebody, have fun with it. Hopefully not on YouTube and make it your own, but hopefully
watch it during your Thanksgiving meal. It's fun for the family.
Exactly. Well, I mean, since apparently Thanksgiving was canceled, right, Brad?
That's right. Well, Zoom Thanksgiving. Yeah.
Right. So for everyone else, who celebrates Thanksgiving, please enjoy, be safe. Come back to us next Tuesday, where we'll continue our MSP Initiative online sessions, and hopefully we'll get you ready for the end of the year, and we'll get you started planning if you haven't already got all your plans together for next year. Brad, thanks for joining us, and thanks everybody for tuning in.
All right, take care.